The beginning point of looking at the roles of the city council and the mayor with the budget, and consequently the answers that will flow from those, is Charter Section 4-40. The mayor prepares and presents to council the annual budget, and then the requirement is that it be prepared in such detail as to the aggregate sum and the items thereof allowed to each department, office, board, or commission as the mayor may deem advisable, and that's the operative language. And then the council takes over, and it says the council shall adopt the budget with or without amendment. In amending the budget, the council may add or increase programs or amounts and may delete or decrease programs or amounts. In looking at these charter statements as to the roles of the branches of government, the City and County of Denver versus Blue case by the Colorado Supreme Court was a case involving the Denver charter, and it required the mayor to prepare the budget. And in that case, the council basically attempted to throw away the mayor's budget and approve its own budget. And the Supreme Court said that the detailed requirements of budgeting, which the people spelled out in the charter, must be complied with in the preparation of the budget. And since that process wasn't followed, they said the city can't operate without a budget at all, so the mayor's budget became the operating budget. And what we take away from that is that the government must respect the budget roles assigned to each of the branches of government by the charter. So looking at our charter, the council cannot change the format of the budget, but is limited to adding, increasing, or deleting, decreasing these words, programs, and amounts. Last year, we provided a memorandum to the council, and in there we explained or tendered our legal opinion on what items, programs, and amounts mean under the charter. The city attorney's office has not changed its opinion on that. And in that, we provided for council's consideration these definitions, that items are subsets of aggregate sums set forth in the budget. Programs and amounts, those are the items subject to amendment by city council. Programs are discrete municipal services for the public, adult, youth, sports programs, that kind of thing. Amounts are the dollar amounts, which are the aggregate cost to provide various programs. So amounts is not all of the resource allocation data contained in the book of so much for salaries and so much for buying basketballs. It's the lump sum total for providing the program. Against the charter language, you also have to look at the overall concept of the separation of powers that is contained in the organic document that controls. With the state, it's the state constitution. With the city of Colorado Springs, it's the charter. And so with respect to the separation of powers, we can look at other sections of the charter that kind of give us the lay of the land on what the separation that the people intended by enacting the charter meant. So under that, the mayor's responsible for all of the executive and should say mayor responsible for all executive and administrative affairs of the city. That's a typo. The mayor appoints and removes all city employees. He directs and supervises the administration of all departments except as otherwise provided. He's the chief executive, enforces laws, again, possesses all of the executive and administrative powers granted to the city of Colorado Springs by the Home Rule Amendment of the Colorado Constitution, is the head of government, executes all legal instruments, and executes all contracts and agreements. The whole city is basically subject to being run by the mayor. The council powers, it's the legislative branch of the city, and all legislative powers of the city conferred by the Constitution are to be wielded by the city council except as otherwise provided in the charter. The council appoints the auditor and the utilities director. Then council reviews and approves personnel policies and procedures and the purchasing and contract rules and regulations, and has all municipal powers with respect to operation of the utilities enterprise. Council provides by ordinance a system for collection, custody, and disbursement of all public monies not inconsistent with the provisions of the charter, and it adopts the budget with or without amendment. And then what do we mean by the council's power to adopt with or without amendment? It's back there, and that's section 7-30, adding or increasing programs or amounts and deleting programs or amounts. So looking at the concept of separation of powers, how has the Colorado Supreme Court viewed and interpreted these? And so there's been periodic skirmishes between the General Assembly and the governor over the powers. Under the Colorado Constitution and laws of the state, the governor has, the General Assembly with the state has much more powers in the budget arena than the executive. And so when the Supreme Court speaks and says, but you've gone too far, General Assembly, it's something that has persuasive effect when we look at the powers of the mayor under the charter. The first key case is Anderson v. Lamb. The legislature had an appropriation tied to the allocation of funds to the number of employees, and had a footnote specifying the number of employees that could be assigned to certain job categories. The Supreme Court said, you know, these conditions imposed on the number of full-time employees interfere with the executive authority to allocate staff and resources in administering the funds. There was also a limitation on the Department of Social Services making contract reimbursements under contracts it routinely executed, and they attempted to limit that to $620 per person under these contracts unless the Joint Budget Committee approved. And again, in that case, the Supreme Court said, we hold the requirement for Joint Budget Committee approval unconstitutionally infringes upon the executive's power to administer appropriated funds. By imposing this condition, the legislature is attempting to undertake an executive function. So there's other provisions in the case. They had footnotes limiting the appropriation on certain reports being filed. Again, the Supreme Court said that's a clear interference with the executive authority to allocate staff and resources in administering appropriations. The other significant case I just wanted to talk about is the Colorado General Assembly versus Owens from 2006. And there it was the 13 head notes they enacted, which contained definitions for a lot of different things. Interestingly, legal services was one of the definitions. And then the definitions were tied to limitations on how the appropriations in the departments could be used. And what the net effect of that was it was actually that if money was appropriated, drilled down into one of these little subcategories, that money could not then be shifted by the governor to be used for other needs of even in the department or even in the same division of the same department. So the Supreme Court said an appropriations bill cannot interfere with the executive authority to allocate staff and resources, make contracts, enter into agreements, or limit the administration of federal funds. The power to appropriate does not give the General Assembly the power of close supervision that is essentially executive in power. These are some quotes from the case. You know, we hold all 13 head notes at issue here, including the full-time equivalent, health, life and dental, personal services, short-term disability, etc., legal services, operating expenses, utilities, and multi-use network payments, head notes unconstitutionally intrude on the authority of the executive branch. And they discuss the prior cases. You know, we hold that Anderson, which was that first case I talked about, stands for the proposition that a limit on the number of FTEs constitutes interference with the inherent prerogatives of the governor. So anyway, the key is that it deprives the executive of the ability to allocate resources to pay for outstanding expenditures without first going back and getting approval from the legislature to use funds from lines already appropriated. The head notes thus violate the separation of powers. And so, what do we take away from all of this? The city attorney's opinion from October of last year is unchanged. Council cannot amend the format of the budget, only the programs or amounts. Nothing in the charter authorizes the council to substitute a 12-department budget for the mayor's 6-department budget.
Garbage.
And council cannot get into the weeds with
garbage.
details on limitations or restrictions on amounts allowed for things like employee benefits, whether health, life, or dental, or even severance payments are allowed under the Personnel and Policies Manual, the PPM. What council may do is increase the money and amount for an aggregate sum provided in the budget for a program. But with that done, it cannot tell the mayor how to operate the program, whether to do it with employees or contractors, or how to apportion the amount between operating costs and personnel and service expenses. So last year, we did speak about the major legislative budget determinations. It was contained and discussed in a memorandum the city attorney's office provided in 2012. And the concept of that major legislative budget determination is from the Colorado General Assembly versus Lamb case of the Colorado Supreme Court in 1985, where the court found there that the transfer of appropriation, quote, altered dramatically the legislature's objectives. And as I recall that case, what the governor was trying to do was transfer money from one department to another department of the state. The city attorney's office opined in that opinion that it can hardly be said that an appropriation of $175,000 to repair tennis courts is a major legislative budget determination. So declaring something to be a major legislative budget determination does not make it so, but is just one of the factors that a court would consider in seeing whether or not it is one and should be afforded respect by the executive. And if it is a major legislative budget determination, it still does not require the executive to spend the money. He just can't spend the money on something else. So with that, I'll turn it over to Britt to go over the specific questions that council posed.
Well, I would just like to interrupt this and say that I'm surprised that this is coming up today in this context. This is I had no knowledge that this discussion was going to come up like this, and if we're going to follow the logic here, why don't we make one department and one line item and be done with this? This is frankly, if we were going to have this type of a discussion today, we should have had some notice that we were going to have this discussion so that we would be prepared. So I think I will suggest that we go into a recess for a minute and before we have this discussion and see if we want to. I personally would want to get some information and facts that I think would not agree with these positions that have been done. I don't know what the rest of this body thinks, but I think that it's something that is a major issue, because if we have no authority to do what we are saying we are asking to do, then I think we as a council should have a little discussion about it. So before we proceed, I'd like to have a little bit of discussion on this. Councilmember Snyder.
Yeah, I would just like to say, for the record, President King, you showed surprise in not knowing about this. You do that on a regular basis, so I expect you to have no more amendments at the dais and take some of us by surprise. Does that make sense?
Councilmember Snyder, this is something that they could have easily told us that they were going to bring forward, and could have discussed about it.
So work on your amendments.
So I think your comment is out of line, so I will
Mr. President,
take it in context with that.
respectfully, I just wanted to say that it was listed as an issue under the documentation that Councilman Knight presented to us. So we just were responding to that as an issue in the in his presentation that's to come.
All right, any other discussion you want to have about this issue, or you want to, Councilmember Knight?
Yeah, I can reclaim it. I don't think it's worth the effort. We've been getting the same old rhetoric now for a year that, as we've talked to other attorneys and other individuals, they've once again cherry-picked. I mean, we can take a break and form it, or I can offer a counter now, but that has been validated by other attorneys.
Okay, any other comments? Councilmember Bennett?
Well, they have some specific questions that council had that I'd like to hear the answers to before we proceed. And we haven't got to those yet. And to me, it would be appropriate for us to get our questions answered from our legal department before we start the markup session.
Okay. Other thoughts? Okay, Brett, come forward and we'll listen to you, and then we will have a discussion among council how we want to proceed.
Well, good morning, Council. My name is Britt Haley. I'm from the City Attorney's Office in the Corporate Division. And just to start off, I think question number 1 was answered by the slide presentation, so I will just jump right to question number 2, which was under City Charter 440I, doesn't the ordinance adopted by Council last year qualify in the quote-unquote except as fixed by law language of the Charter? So our answer to you is that, first of all, this language, except as fixed by law, refers to controlling general laws such as federal statutes, rules, or regulations. Although ordinances properly adopted by council are ordinarily legally binding, an ordinance that violates the separation of powers is void and of no effect. The Colorado Supreme Court on several occasions has found that restrictions placed on the annual appropriations bill by the Colorado General Assembly to be void as unconstitutional encroachment on the executive powers. An appropriations ordinance properly adopted and in compliance with the separation of powers would qualify as fixed by law. However, you've got to keep in mind that Charter Section 7-50 clearly states that the budget is approved and appropriations are made for only a single fiscal year. An appropriations ordinance's content will only be effective for the single fiscal year for which it was approved. Thus, the 2014 annual appropriations ordinance pertained only to the approved budget appropriations for the 2014 fiscal year. And I'm happy to take questions at any point, but I'll just keep going through the questions until I get a question to keep this moving along. So question number 3, council asked, how may council require its 12 departments be reflected in the budget that the mayor presents? The answer that we would give you is this would require an amendment to the city charter imposing this requirement. Similarly, question number 4 asks, recognizing that council has the only charter, let me see if I can skip forward here. Recognizing that council has the only charter authority to establish departments, and we find that in section 5-10 of the city charter, how can the mayor present a budget with appropriating departments? The answer is the mayor's authority to propose an annual budget with appropriating departments in such detail as the aggregate sum and the items allowed to each department and as the mayor may deem advisable is found in City Charter sections 410 and 440I. The council and the mayor do have concurrent authority to establish departments. In accord with City Charter 5-10, the council has adopted an ordinance, City Code, Section 1.2.312, which recognizes the authority of the mayor to, quote, establish departments, divisions, offices, or agencies, in addition to those created by the charter necessary for the efficient administration of the municipal government, and to prescribe the functions of all departments, divisions, offices, and agencies. In this manner, council has recognized and acknowledged the establishment of the departments necessary for the efficient administration of the city is an executive and administrative power properly vested in the mayor in accord with City Charter 5-10. The two work together. Question number 5 was a similar question. It said, how can, quote, super departments, end quote, be legal? And The answer to that is, although we're not, super departments are not referred to in the charter by that name or by the city code, there is legal authority in city code section 1.2312 for the establishment of departments by the mayor. The exercise of all executive and administrative powers granted to the mayor by charter section 4-10 includes the power to organize the units of city government, whether they're called departments or not, except for those that are charter-designated departments. This is part of the administrative power of the mayor. Finally, the establishment of the appropriating departments in the budget submitted by the mayor is pursuant to section 4-40I, and of course, we've already discussed that in question number 4. So question number 6, also similar, was what is the legal foundation for these appropriating departments? And we've already discussed our findings on that. Question 7, must the requirement of 12 departments be made by city charter? Our answer is yes. An amendment to City Charter 4-40I is necessary if the mayor is to be required to prepare and present a budget with a defined or otherwise specified number of departments. We would also assume in that case that that would define the functions of those departments. So question number 8. Council would like to see what that requirement would look like. So the answer from our office is that if a majority of council will provide direction on the specifics of what it wishes in a charter amendment, then the city attorney's office can certainly draft that. Some possibilities that we've come up with include, you would possibly amend the city charter 4-40I to insert after, the budget so prepared shall be in such detail as to the aggregate sum and the items allowed to each department, office, board, or commission as the mayor may deem advisable. You would insert, except that the budget for the following departments shall be separately set forth, and then describe what those departments are that the city council would be looking for. And then another possibility is that 440I could be amended to insert after the mayor shall prepare and present to council the annual budget. Then after that, you could insert the words in a format prescribed by council by ordinance for the ensuing fiscal year. So those are a couple of ideas, but depending on what aspects council is seeking to achieve through a charter amendment, we would need further detail in order to draft the language that would fulfill council's desire with regard to that. Question number 9 was, given the constraints on the charter as you see them, describe to us a method to increase transparency and accountability of the executive branch to the people who pay the taxes, and how they can see where their money goes. Is that through a charter change referred to the citizens? Could it be a city code provision? The answer. So we're not sure that the city attorney's office can answer this question because the concepts of transparency and accountability are political concepts that have no legal definition until and unless defined, excuse me, I think you started me, unless they're defined by a legislative body or the electorate through a charter amendment or an ordinance. The city attorney's office can certainly draft a proposed ordinance or ballot language, but we'd need clear policy direction from council on what types of controls or reporting requirements they are seeking. Thank you very much. That is needed. I'm going to take a quick water break. So if you give us clear direction on the types of controls and reporting requirements that you're seeking, the city attorney's office could draft that kind of language. If the focus of council is controlling the budget authority of the mayor, it would have to be adopted by a charter amendment approved by the voters. Answer number 10, or question number 10. How can council require that appropriations be made only through certain departments or with specified departments? Answer is we've already identified a charter amendment as one method to achieve more control over the form of the budget. A charter amendment that would restrict or regulate the exercise of executive power may result in additional council control over the budget if the voters approve such a recalibration. In addition, nothing in the charter or code precludes cooperation between the executive branch and the legislative branch concerning how the mayor and council will implement and exercise their powers. Their respective powers, I should say. The problem arises when council seeks to exercise control over the executive branch without the executive branch's agreement or consent. That is the essence of intrusion on the separation of powers. Finally, and I'm sorry about this tickly little cough I have. Question number 12 came in on Monday from Councilman Miller, and it was what we have heard from the city attorney's office last year on this very point is that one department would be inappropriate. By what criteria is one department inappropriate and 5 or 6 appropriate? The answer is found in the plain language of the city charter. The plain language of section 4-40I indicates that one budget department would likely violate the charter. Section 440I states, the mayor shall furnish to the council estimates in writing of the probable expenses to be incurred in the several departments of the city for the ensuing fiscal year. The criteria provided by the charter are found in 440I, several departments of the city, and, excuse me, quote, the budget so prepared shall be in such detail as to the aggregate sum, the items thereof allowed to each department of office, board, or commission as the mayor may deem advisable, except as are fixed by law. Those are the criteria that the charter places for that question. So those were the 12 questions that we received from council. Those are the answers that have been researched and vetted in my office, and Tom and I are prepared to answer any questions that council has now or may have later.
Did you prepare those in writing for us?
I do have them in writing, and I can check with Winetta to see what format she'd like. I don't think we have any problem giving them to you in writing.
Okay. I think that would be beneficial to do that. So what is the pleasure of council? It seems to me that our deliberations today are to a degree hampered or made meaningless if we have no ability to do anything but accept anything that the mayor wants to do with consent. So it would seem to me like we have, that is the only power that is vested in what I am hearing today, that if we do not have consent for what the mayor wants us to do, that we are powerless. Is that kind of the essence of what you were saying, Brett? Is that where you're at on that?
No, I guess I wouldn't characterize it that way. I would look to the council powers in section 3 of the charter. And under that, in terms of the budget, the council does have the ability to add or increase or delete or decrease. And that is, that's been the opinion of our office for as long as I've been there. So I think that your work can be done in the constraints of the charter.
Okay, Councilmember Martin.
I would agree with that. I think in the last few years under this form of government, we've done just that. That's what the markup session is for. And I think in the agenda we have today, we have several items listed under markup, and we certainly have the authority to make decisions based upon those. I think the way the agenda is listed today, there's something about issues later, and that may be a little more difficult for us to do, but we certainly do have authority to work the markup items that are listed in the agenda today.
Councilmember Bennett.
Yeah, I have a couple of questions. Just so trying to get us all on the same page a little bit. Where do you see the 12 departments, the concept of 12 departments emanating from?
I'm sorry, what was the last part?
Where do you see the 12 departments emanating from? Where did that concept come from? It just didn't come from out of the air, did it?
I don't think it came from out of the air. I believe that the charter sets a specified group of departments, but the charter also recognizes that over time a city will need to designate other departments. And the city council has also acknowledged that in its code provisions, because cities don't stay stagnant. They're vibrant things. They move, and there needs to be flexibility. So I think that there is the capacity to identify departments, to give them functions, and that's consistent with the powers of a city.
Yeah, if I could just add, I think that's evidence through the mayor breaking out the Parks Department as a separate department this year in this budget, which was different than last year's.
So does the mayor have the power to establish the number of departments? Does council have any, we can take away programs and resources, but does the council have any involvement in the identification of departments?
I think the answer is clearly under Charter 5-10, the council does have that power. But I think what we're trying to say to council today is that in the formation of the budget, our charter very specifically prescribes how the budget is going to identify those things, and really gives the preparation of the budget, the format of the budget, gives that power and responsibility to the mayor. And so there doesn't, I guess the question is, if 12 departments are going to be funded, or those aspects of city government are going to be funded, can they be funded in the format that you've been presented by the mayor? And I think that you have seen some change over time in the way that that's viewed as the council mayor form of government has matured, so that you do now see that there is a 6th department designated to parks, and that was apparently a persuasive argument, and the mayor took that into account in forming the budget. So yes, there is a separate function with regard to assigning departments and giving them functions and giving them life, but what we're trying to help you avoid is the conflict that came up in the Blue case, where the Denver City Council didn't follow its charter requirements, and the Supreme Court found that that was wrongful. So what we're trying to urge you to do is to find a way to work within the format of the budget that the charter designates in order to do your work as council in determining the appropriations.
Okay. And my final question is more historical, and maybe Cara can be the better one to answer this, but this discussion over the number of departments, how many departments were there before we went to this form of governance, and is this an outgrowth of our new form of governance?
I'll take a stab. I think in the past, when you had the manager council form of government, it was really council's decision. And then the city manager would present the budget in accordance with that. And obviously with the change, we have the executive who's now running the city, and that's the format that he chooses to present his budget in. So I think therein lies the difference.
So it is an outgrowth of the governance structure.
Absolutely, and the powers, and I think the intent of the voters when they passed the strong mayor form of government, to give the executive the opportunity and the duty and the mandate to manage the city.
Okay, thank you.
Councilmember Pico.
Well, I disagree with some of this because you're leaving a couple of things out, and part of that is written in the city code, in a whole section on financing, budget creation accounts, appropriation of tax levies, transfer of funds within departments, and so forth, in section 1.5.100 series. And in there, it has quite a bit about council authority to amend things and change things, and it specifically has a council authority to move money between departments. And therein is the crux of the issue, I think, because the charter, I don't agree that there's anything needs to be changed in the charter. The charter is pretty clear in its language. It has departments, and there are in fact 19 departments. And what you're talking about here is ignoring city code, very specific, that gives that authority to council to approve by resolution the movement of money between departments. Now, so far as, if you want to make appropriating departments, there's nothing in the charter that talks about appropriating departments. It talks about departments. And so I think there's reading an awful lot into that to say that, well, we could just make super departments or appropriating departments or consolidate it, whatever. What I'd be quite happy to do would be to agree to consolidate those 19 departments to actually match the departments. I think that'd be a great step forward. But the idea that if we're gonna have 19 departments, we should appropriate to those 19 departments and follow the city code that says council has the authority to move money between departments and to make amendments through that.
Councilmember Pico, if I may respond.
Sure.
We would concede that the charter is not an example of absolute clarity, okay? I mean, it's not, and you have to look at it fairly carefully. It actually, if you look at it fairly carefully, it doesn't actually create, it doesn't have language that says there shall be a Department of Public Works. It doesn't have that language. It talks and uses the word departments. So with the language, the overarching language on the separation of powers that we've gone over and the provisions on the budget, we had explained last year the concept of there being operating departments versus there being these appropriating departments, which are determined by the budget in the format in which the mayor submits it. And I appreciate that you disagree with the legal opinion on that. But the executive does understand, and we have clearly respected that there can't be a transfer of funds from one of the appropriating departments to another appropriating department, at least, until something occurs, which is the mayor coming forward, asking for that change, and the city council approving that change. I think, it's clear that there was a disagreement in 2013 with the council adopting a budget that had 12 departments in it. And on that, the mayor had given a letter back to the city council indicating he does not feel bound by that. But nevertheless, I don't believe that as a matter of practice, there has been any transfer of funds between what the council had identified as those 12 departments without coming back to the council for specific authorization.
Yeah, I'll concede that no such transfer has occurred, but the point being that that's how it should be appropriated. That disagreement still exists. That the charter does not specify the departments specifically in great detail. It does identify, as you read the language, at least 12 departments. My point is there are actually 19. I'd be quite happy, like I said before, to consolidate those departments and make it consistent. But in the absence of that, I think, particularly with the language in here that's in the code, to be consistent with that, which you guys keep ignoring, that, at least my impression is, that we should appropriate to those departments as they exist, not to some consolidated appropriating department. There's nothing in the charter that talks about that.
Yeah, well, the code cannot supersede the provisions of the charter itself. And as I indicated, I mean, I can't offer you anything else up here because the charter doesn't specifically create departments. It talks about there is a head of a department or there's a director of public works, but it doesn't say there's a department of public works. So in each of those cases, when you look at it, other charters of other cities will say there shall be a police department, and the head of the police department shall be the chief of the police, who shall be responsible for the behavior of the police officers and the enforcement of all laws and those kinds of things. This charter doesn't have those kinds of things. If it had a statement saying there shall be, a department of police, a department of fire, a department of the city clerk and stuff, your view would be substantiated and we would wholeheartedly agree with you. So, I respect your feelings, but, this is the legal advice that we've we've come up with based upon our best examination of what the charter says and the law.
Well, I appreciate that, except that where I differ is city code and the charter are not in conflict. City code expands on it, and you're ignoring that part of it to come up with an interpretation that is in violation, in my opinion, of city code. That's not appropriate, I don't believe.
Are there any other questions for Ms. Haley or I?
Councilmember Knight.
No, I don't have any questions for you. I have a statement. I mean, we've heard the same old rhetoric. We've had this argument now for several years. You know, in answer to Merv's question about beforehand there were multiple departments. When we first came on council, you know, I was told by our legislative council at that time that had the issue that the only reason for creating the super departments was to get around the code that says you can't transfer without department. But all that fact aside, I mean, we can sit here and argue some more, or the city attorney's job is to provide advice. We heard that advice. We are elected officials. We are the one that take and vote. So they've given us our advice, noted. Let's proceed.
Okay, any other comments? Councilmember Bennett, you want to? I will just indicate my disagreement with the advice that has been given to this council by the city attorney's office. I do not agree with it. I think that it is something that is not appropriate in light of the discussions that we've had further on this issue, and I think that it's something that is the ability to put a definition in front of a department to call it an appropriation department or whatever you want to call it is a subjective decision and does not have basis in the construct of the language. I would like to go back to one question, though. Tom, you had some definitions that you had listed. I think you listed some definitions on item or program, and I think you put some definitions to those, and I don't know if we've seen those definitions before. I would like to have those talked a little bit about again.
Yes, Mr. President, those are the definitions. That's a very short summary of what was stated in that October 1st, 2013 memorandum. And if you'd like, I could read just those paragraphs from the memorandum.
The one specific one I wanted to, well, I'd probably like some discussion about, but the line item that talks about in the charter that the mayor has line item veto, is this the item that you're referring to in this
No, sir.
particular illustration here?
No, sir.
Okay.
No, there's items in one section of the charter, and then line items is something completely different. The line items that the mayor has the authority to veto are the line item changes that the council makes to the amounts for programs and amounts. So if you, for example, decide the police department, that's a discrete department. If you want to add $100,000 in the police department, and it's one of your changes on the budget you adopt, that's a line item, and the mayor can do that. The items I'm referring to here is in a different section of the budget that talks about that the mayor prepares it with items, and the items are, the budget shall be in such detail as to the aggregate sum and the items thereof allowed to each department. So in this context, we had said items appears to refer to the subsets of the aggregate sums detailed in the budget that are allowed or attributable as either expenditure or revenue to the departments of the city. Items suggest that in addition to the dollar amount, there will be some identification or explanation of the purpose for or use of the expenditure or revenue. In addition, the context implies that each department of the city will have an individual budget that lists the items specific to that department. In fact, the annual general fund budget has historically been prepared, presented, and approved as a collection of department budgets containing items that make up the aggregate estimated revenue and expenditure sums. Departments, for budgeting purposes, do not, however, mirror the operating departments of the city as depicted in the organizational chart included in the budget document. For example, the Parks, Recreation, and Cultural Services operating department and its various operating divisions, enterprises, or units is included in the Parks, Planning, and Public Works Department for purposes. So anyway, an example of item was when we went to the general costs section of the budget. There is an item in there that was captioned legal defense, okay? So that item cannot be moved to another department. The council doesn't have the authority to add items to the council department and subtract the item from another department. It can increase or decrease the amount. So on that item, the city attorney's office is a program, so programs and amounts, so if the program is in the Parks Department and there's a program of recreation services, then on that program, the council can say, we can't afford adult recreation services this year, we're going to delete that program. Or the council could say, you know, we would like to see a program of toddler recreation services and add that program. And we'll put an amount in there, we'll add an amount of $100,000 for it. So the item is used in that context, not the other section about then when you make your changes, you make them as line items, and then the mayor can veto line items if he wishes.
Councilmember Knight.
I'll go back again to the function of the city attorney office is to provide advice. The city attorney is not the one that defines or makes rulings on the definition of the charter or defines language within the charter. That is a function of the legislative branch to, in city code, expand the charter. And I have made repeated, and I'll repeat it again, offers to sit down with the executive branch and sit down and craft legislation that is mutually agreeable that defines these terms. And I have not brought anything forward because they have never accepted, and I didn't want to do anything unilaterally. But these definitions on paper are opinions of the city attorney and not matter of fact.
Okay. Councilmember Pigo.
From Councilmember Miller, the only foreseeable reason for fabricating departments is to deliberately allow the movement of funds between the larger departments. If that is not the goal, then what other purpose would be there in creating the departments? And another point very appropriately is who's the head of the department? If you have an appropriating department that has several in it, who's the head? But I think we've beat this one to death. I think we ought to move on to the puts and takes, the markup session.
Okay. All right, we'll move ahead. I just expressed my disappointment. So.